Good afternoon, or good afternoon Moscow time. We should be in Moscow. It's good morning from British Virgin Islands, and good evening if you're in the Far East. This is the 12th annual virtual conference of the ABA in association with the Russian Arbitration Association. And today we're going to have two very distinguished speakers, Nikolay Pokryshkin, Sergey Petrachkov, both of whom are eminent practitioners in the Moscow legal market. Sergey is the head of ALRUD's dispute resolution team and deals with restructuring and insolvency. He comes highly recommended in chambers and partners as anticipating solutions and being good with clients. Nikolay Pokryshkin, formerly from Freshfields, is at KK&P, a very well-known trial law firm in Moscow, described as a raging bull during hearings and sharp and creative. So we're hoping for some raging bull during today's session on arbitration and insolvency. And without further ado, sorry, Nikolay. I
will limit my rage intentions during today's session. So
yes, I hope you leave your rage for Sergey, not me. Without further ado, I'll hand over to Sergey, who will deal with some elements arising out of the Russian law element of this talk.
Yes, thank you very much, Peter. Thank you for the introduction. Hello to everybody. Today we'll speak about correlation between arbitration and bankruptcy. Me and Nikolay will cover the issues of Russian law, and Peter will cover the issues of BVI and some other jurisdictions.
I suppose there are some issues with the connection.
I think we may have lost Sergey a little bit.
Do you hear me?
Now, yes.
Yeah, I'm sorry. The previous slide, please. Yeah. So the situation differs if we are speaking about the bankruptcy of the plaintiff and bankruptcy of the defendant, and the approach of Russian courts is different depending on whom bankruptcy we have. I'll speak in more details about these two different situations, but in short words, I would say that the situation with regard to bankruptcy of the plaintiff, in my view, is more interesting. It is not clear-cut as bankruptcy of the defendant, and there is no much practice of the Russian courts, and especially the Supreme Court. There was quite a well-known case of Radius T in 2017, but I would say that this case did not make the situation clear. And the case law after this precedent of the Supreme Court remained the same, and the approach to enforceability of the arbitration clauses or non-enforceability remains the same, like 70 to 30%. As to the bankruptcy of the defendant, from the Russian law perspective, it is crucial which stage of bankruptcy we have. And here you could divide three main situations, three main scenarios. The first one is you have arbitration proceedings and you obtain award before bankruptcy, or even before supervision procedure. Because in Russian law we have two main bankruptcy procedures: supervision and receivership. Yes. So the second scenario is when you are between supervision and receivership, and the third situation is when the receivership procedure is introduced. Next slide, please. So as I said, before introduction of supervision, there is no impact of bankruptcy on arbitration. It means that if you have, for example, pending arbitration proceedings, you could pursue with these arbitration proceedings. The situation differs when the supervision is introduced, because as soon as the supervision is introduced, all monetary claims against the defendant, who is the debtor, who is the bankrupt, or potentially bankrupt, they could be initiated only in the course of the supervision proceedings. And if you manage to initiate arbitration proceedings before introduction of supervision, then it means that you could pursue these arbitration proceedings. But for you, it is crucial to obtain an award before introduction of receivership, because otherwise you will not be allowed to recognize it in the course of bankruptcy. So I'll be speaking afterwards about some legal remedies, how to do it, and one of them is, for example, partial final award. So in short words, if you have arbitration proceedings before introduction of supervision, it is recommended for you to have an award before introduction of receivership, so before declaring the debtor bankrupt. Because as soon as the receivership proceedings are initiated and the debtor is declared bankrupt, it means that tribunal must terminate the arbitration, and all claims should go to the state court. And of course, it is relevant when you, as the creditor, would like to use your rights in the course of Russian bankruptcy proceedings. I think Nikolay will touch this situation when, for example, you have the assets of the debtor somewhere abroad, not in Russia, and I think it's up to the creditor whether to go into Russian bankruptcy and to realize all its rights as a creditor in the Russian bankruptcy, or maybe there are some assets abroad. And here the situation is quite tricky for the other creditors and for the bankruptcy receiver, because unfortunately this situation is not that much regulated by Russian law, and just because we do not have transnational bankruptcy provisions in Russian bankruptcy codes, and just because Russia is not a party to any bankruptcy law treaty.
Can I just jump in there, actually, Sergey, because your graph actually is a very useful way of demonstrating some of the differences in the common law world. So if you look at your first point, which is filing of the bankruptcy petition, and you say there's no impact on the arbitration. Now this is where there's a sort of a slight tension between bankruptcy lawyers and arbitration lawyers, and in the common law world there certainly is a very pro-arbitration approach. So for example, suppose you have a company which it has a debt. The debt is owed by an English company or a BVI company, and they issue winding up proceedings in the English courts or in the BVI courts. The debtor, even if the debt seems obviously due and owing, if there's been an obvious default on the debt, sorry, the debtor company is entitled to say at that stage, but there's an arbitration agreement. You, the court, shouldn't determine whether or not the company is insolvent or not, or whether this debt is due or owing or not, because there is an arbitration clause. And certainly in an English case called Salford Estates, the pro-arbitration approach was that irrespective of the merits, if there is a defendant company saying, I dispute this debt, it then has to go off to arbitration to be resolved. Now that can cause frustration amongst bankruptcy lawyers, and certainly amongst the the claimant's company that says, well, it's obvious he hasn't paid his debt, so I've got this debt instrument, he hasn't paid his installments. He raises some spurious dispute, relies on the arbitration clause, and then gets the winding up petition dismissed or stayed. And certainly in the BVI, there had been the Salford Estates approach hadn't initially been followed. So C-Mobile is one of the cases in the Court of Appeal where they say, well, yes, we are pro-arbitration, but equally, if it is not defended on bona fide grounds, on good faith grounds, and there's no evidence of a substantive defence, then because the bankruptcy procedure, the liquidation procedure, we'd refer to it in BVI, is a collective process, it's for the benefit of all creditors. So they're not adjudicating on the debt, they're saying that this party cannot pay, and that it's for the benefit of all creditors that the company be wound up. Now there's been a slight development in the last 2 months really in the BVI, and there are two cases called Lennox and Fair Cheerful. For participants, I've got a note which I can circulate afterwards if you send me an email, which sets out the more English approach, namely, as soon as a party simply raises the facts that it disputes the debt without even setting forward any grounds, simply we dispute the debt, but then relies on the arbitration clause, then that would be sufficient, certainly on a couple of recent first instance decisions to knock out the bankruptcy provision.
Actually, here in Russia, we have a choice for the creditor who may choose whether he wants to proceed in arbitration during the supervision proceeding or prior to introduction of supervision proceeding, or whether he is going to join insolvency. So actually, it's a kind of topic which I am going to discuss. Sergey, should we discuss anything on this slide at the moment, or should I go to?
Yeah, frankly, I finished, so the floor is yours. Yeah.
Thank you. So the next slide, yeah, this slide is fine. So generally, in Russia, the creditor could choose whether he wants to continue with arbitration or whether he's going to join insolvency as a creditor and benefit from all the rights which are given to the creditors. I believe that these choices strongly depend from another choice, whether the creditor is going to get recovery from the Russian assets of the debtor within the scope of the Russian insolvency case, or whether the creditor is going to just get an award to enforce it outside of Russia and to get satisfaction on the basis of assets of the debtor located outside of Russia. Of course, at the beginning of the insolvency proceedings, usually creditors don't have a particular idea about the way to proceed with their claim, and they need some additional time to collect information about other creditors of the debtor, or to collect information about assets of the debtor located in Russia or abroad. So there are main factors affecting the choice is firstly location of debtor's assets and amount and composition of other creditors' claim. If you see that there are a lot of creditors and they have a big amount of claim in Russia, and there are no substantial assets of the Russian debtor in Russia, then most probably you will try to get an arbitral award to skip. You will skip Russian insolvency case because there is nothing to get in Russia, and to try to get satisfaction outside. However, there are some other factors affecting this choice. For example, if you are going to want to participate in the first creditors meeting in a Russian insolvency case, then of course you have to skip your arbitration, file a motion to suspend or terminate arbitration proceeding, and then join the Russian insolvency case. If you are participating in first creditors meeting, then you could vote for example, appointment of a particular receiver, for choose of the next stage of bankruptcy, etc., etc. So in such a case, you would affect the further way of the insolvency case in Russia. Another factor affecting this choice is the complexity of the case. Usually, Russian judges are not quite sophisticated in complex economical relations and complex agreements, especially agreements concluded under foreign, non-Russian law. So in such a case, it's better to get an arbitral award first, for example, during the supervision, and to present this award to the Russian state court in the next stage, during the receivership. In such a case, experienced arbitrators will consider your case on merits, and as an ideal, the Russian court would just check it on the very basic breach of the convention. However, in practice, say that Russian court just tend to reconsider arbitral awards on merits, but it's not a simple based conversation. However, it's easier way to get an award first and then to present the award in the next stage of insolvency, if the case is quite complicated. If it's a simple claim under Russian law with quite solid material evidence on this case, then it might be easier just to present it in an insolvency case. Another factor affecting this choice is probability of termination of the insolvency case in the very first stage. For example, it might be a settlement agreement within the insolvency case with other creditors, or it might be withdrawal of the initial claim of the first creditor's insolvency case, or other reasons why the insolvency case in Russia could be terminated. And if you have an information that it is quite probable, then maybe it's not reasonable to suspend or terminate arbitration proceedings, because in such a case, if you terminate it or suspend it, you will find yourself within a year or half of a year without an insolvency case because it was terminated, and without an award because you have skipped your arbitration proceedings, which is quite a pity situation.
Sorry, Nikolay, could I just ask a question about the supervision stage? So at this stage, has the Russian court appointed a supervisor? And then what role do the directors continue to have? Do they continue to have power to defend a bankruptcy?
Yes, of course. Previous management of the debtor, management appointed by the shareholders of the debtor, still have their authorities and their powers, and they could represent the company, the debtor, in relation with other parties. However, I will say, supervision receiver, let's use this term, have a right to challenge particular transaction. He is going to collect information about ongoing and previous business activities of the company, and he has a right and a duty to get a decision on approval of a particular transactions which have to be made by the debtor. For example, if CEO is going to make a transaction on sale of the main asset of the company, then he will get not only approval of the shareholders meeting, also he had to get an approval by the interim receivership, supervision receivership manager. Otherwise, it will be a ground for challenge of the transaction. But generally, yes. Generally, the debtor is represented by his former management at this stage. However, if we are talking about the receivership, the next stage, then in such a case, authorities of the previous management are terminated, and the receiver will get the whole power of the managing body of the company, and he will represent the company in relation to the other parties.
And then if it's in receivership, so on your second stage, which I think you were coming to, would the receiver normally continue in arbitration, or would he say, the company's getting sued, I think we ought to settle the claim, or whatever? How would that work?
Yeah,
would it automatically terminate the arbitration, or?
No, of course, it will be not any automatic termination of arbitration, because an arbitral tribunal will have a choice whether it's ready to continue with arbitration. But from the prospect of Russian law, of course, the arbitration proceedings should be terminated due to the next stage in receivership. And the Russian receiver, of course, he will just use the Russian law position in this respect as a representative of the debtor. And he will say in arbitration proceedings that yes, now those proceedings should be terminated. And usually it raises some place for a dispute between a claimant and respondent in arbitration procedure, whether limitations of Russian insolvency law is a ground to actually terminate or suspend the proceedings, or it's possible to continue this arbitration proceeding. But from the prospect of Russian law, of course, it's just a ground to terminate those proceedings. And moreover, any asset which will be recovered by the claimant on the basis of the award which obtained in such proceedings would be considered from the prospect of Russian law as then a kind of unjust enrichment. And there are two types of qualification of such payments in Russian court practice. The first one is the preferential transaction, preferential payment, and the second one is the unjust enrichment. And in such a case, such payment may be challenged within the scope of Russian insolvency case, and if the claimant creditors were quite active to get an asset abroad, then still we risk that other creditors or the receivers would challenge such transaction and trying to get the money recovered by from the claimant to the bankruptcy asset in the Russian insolvency case. Of course, there are some specific schemes of avoiding such a risk, including assignment of claims, etc., etc. But generally, I would just point that such risk exists, and it's a big problem. Sometimes, in our experience, arbitral tribunals raised this issue on the basis of the defendant's arguments in this respect, and actually, claimant could argue that if in the future he recover some money from the debtor on the basis of this award, then the claimant promised to the arbitral tribunal or to the foreign state court just to transfer those money recovered from the debtor asset to the bankruptcy estate. It's a quite interesting construction because actually we're talking about just a promise to the arbitral tribunal or a foreign court, but usually it helps to continue arbitration. And of course, if in the future the creditor fails to fulfill such obligation, then it might raise civil and criminal liabilities for the claimant and his representatives as well. So it's quite a complex issue.
That's also a sort of a useful counterpoint to the sort of the common law approach, because the common law approach, I think receivership probably would be equivalent to the appointment of a liquidator. So when you wind up a company, a liquidator is appointed, and then certainly under English law and BVI law, and I think Hong Kong and Singapore, you have then the benefit of a moratorium, which essentially means that no party can continue proceedings against the company unless it gets the court's permission. Now there are some occasions where the court will grant permission to continue a case against a company that has been liquidated, but they're usually quite specific factual cases. So, for example, if you've obtained an award on liability in arbitration, and then the defendant, the respondent to the arbitration, is wound up, and you wish to crystallize or at least have an award on quantum in order to know what is the amount that you have to put in for your proof of debt into the estate, then potentially the court could grant permission to continue the arbitration. But it's quite a difficult exercise, because obviously at the stage a liquidator is appointed, although the directors remain in office, they have no powers to deal with the affairs of the company. And so the issue then becomes, well, who is going to fund the arbitration to defend it? And that becomes one of the issues as to what is the purpose in continuing with an arbitration or continuing claims against a company that has been liquidated if in fact one, they're going to be undefended, and in any event you're simply going to put in your proof of debt into the bankruptcy estate. So I think that's probably one difference with the common law jurisdiction.
To be clear, there is a similar moratorium in Russia under Russian law. Of course, Russian law doesn't allow to continue with arbitration during the receivership stage, and it just seems that there is no supervision stage or an analogy of supervision stage in a common law jurisdiction. But if we are talking about a real insolvency, which is a receivership stage in Russia and a winding up common law jurisdiction, then in such a case, of course, our jurisdiction have quite direct law provision prohibiting any recovery outscope of the bankruptcy. But we are talking about practice, and in practice, usually foreign courts and foreign arbitral tribunals allows to continue such arbitration, and there is also a quite interesting discussion about nature of limitation of Russian insolvency law, because there is a position which was, for example, admitted by the High Court in several cases connected with Russian oligarchs, that insolvency provisions of Russian law, those of them which have material substance, which construed, for example, grounds for liability, and etc., they do have an extraterritorial effect. So they do have an effect which might be implied outside of Russia. While those provisions of Russian law, which have a procedural nature, for example, particular limitation on filing of the claims and petition to particular bodies, terms, and etc., and such a procedural provisions of Russian law do not have an extraterritorial effect, and they should be applied within the territory of Russia only. And on the basis of this distinction, there is a quite good position that limitations of Russian insolvency law on filing claims outside of the Russian bankruptcy case are not applicable outside of Russia. And on the basis of this concept, quite usually foreign courts and arbitral tribunals continue to consider claims against Russian debtors, including claims in arbitration proceedings, with respect to procedural nature of limitation to present such claims in Russia. Of course, there is a very big field for discussion, because you must say that actually moratorium is the nature of insolvency. So what is the reason to start insolvency proceedings if creditors do not benefit from the moratorium against all the claims? However, there is no unified approach in Russia and outside. So it's just a field for battle.
And I think moratorium is also working even at the supervision stage, because you cannot enforce your reward. So even if you obtain it just before initiation of the supervision, but the supervision is initiated, so you could just recognize it in the course of bankruptcy and include your claims into the register, just because after initiation of supervision, all enforcement proceedings should be stopped, should be terminated.
Yes, that's why the main question is whether you're going to enforce your award in Russia. Because if you don't want, then you could just ignore Russian proceedings and just to be prepared to present relevant arguments to the arbitral tribunal to get a final award and enforce it outside of Russia. And with respect to the timing, I think we should go to the next slide just to end my part of our discussion. Thank you. So another interesting question is opportunities for settlement with a debtor who is under insolvency proceeding. I'm talking about settlement in arbitration proceedings, while the debtor is under insolvency in Russia. So in addition to standard requirements for such settlements, there are some particular specific requirements prescribed by the insolvency law in Russia. So first of all, of course, you should get or be sure that the debtor provides the arbitral tribunal with the corporate decision on approval of the transaction. I'm talking first of all about the mayor transaction and the interested party transaction. And if we're talking about supervision provisions, then such approvals should be provided by the just general meeting of shareholders, because they still have their rights and they still vote on this issue. But if we are talking about the receivership procedure, where the permanent receiver was appointed, then such approval should be provided not by the general meeting of shareholders. No, such approval should be provided by the general creditors meeting. So in such a case, the creditors will decide whether they're ready to allow the debtor represented by the receiver to make a relevant transaction. And from the prospect of Russian law, settlement agreement in arbitration is clearly a kind of a deal or transaction which should be approved by the creditors. The interesting question is whether other deals and other transactions which are not mayor or interested party should be approved by the creditors meeting, because there is no direct Russian law provision applying receiver to get such an approval for every deal, but it still be a risk that such a deal will be challenged by other creditors if the receiver would fail to get such approval. So to be on the safe side for any settlement in arbitration proceeding with a Russian debtor, it should be obtain relevant permission by the creditors meetings of the debtor in Russia. It's strongly mandatory to do it with interested party and mayor transaction, and it's highly recommended to do it in respect to each other settlement. However, it's an arguable field just to discuss whether it's really necessary for the rest of transaction. And if you go back to the supervision procedure, where the receiver is not management of the company, but just supervision body, in such a case you also should get an approval by the supervision receiver to make a particular transaction. And there are just presented on the slide, there are particular types of transactions which should be approved by the receiver. And you should know that in particular cases, the Russian court might make a wider list of the transactions which should be approved by the receiver. So it should be carefully checked prior to settlement with such a party. The next slide, please.
Can I sorry, just going back to the previous slide, please. So in your receivership side, you say the supervision receiver acts on behalf of the debtor as a party to the transaction. So this is a scenario where you have a solvent claimant
yes, for example, yes,
in arbitration, and then you have an insolvent respondent to the arbitration. So what happens if they reach a settlement? What effect will that have? Is it possible for the supervising receiver to pay the award, the settlement amount that they agree on, or and then how does that affect other creditors?
Let's say if we're talking about the receivership stage, then in such a case the Russian receiver wouldn't conclude any settlement in arbitration, because it would be just a direct road to get an liability under Russian law for such a receiver. Yeah. So right. We're talking about situation when the claimant is a bankrupt or insolvent company under Russian law, and the receiver acted on behalf of the claimant in arbitration proceedings from one side, and the respondent in this proceedings is, for example, solvent company. So in such a case, yes, the receiver could make a transaction with other party, but transaction, I mean a settlement agreement, but such settlement agreement should be approved by the creditors meeting. So it's theoretically, I could imagine a situation when the receiver would conclude the agreement from the respondent side, and the respondent is a debtor in Russian insolvency case, and potentially arbitral tribunal might approve such agreement, but it would lead to a huge risk of responsibility for the receiver and the risk of challenging of such an agreement as a transaction in Russian insolvency case, just due to moratorium introduced in relation to the debtor. And of course, it will be extremely hard to make a payment under such settlement from the debtor who is under insolvency. It might lead to a criminal liability of the receiver. So I would recommend to skip such an option. So let's go to the next slide. Thank you. And the last theme, I just want to thank honestly, I do not have a direct and clear answer to the question which I'm going to raise, but I will be happy to discuss it with you guys. So if we're talking about the settlement and arbitration and relevant limitation of the Russian insolvency case, then to which particular types of settlement such limitations are applicable. So it's quite clear that in relation to a pure settlement agreement, I mean a settlement which is approved by the arbitral tribunal when the respective award is issued, it's quite clear that such settlement will be treated as a deal and all the limitation and restriction will be applied. But what if we're talking about agreement on facts? I mean, agreement when the parties agrees that the particular facts took place, but they do not have any agreement on particular payments in this case, and they are not going to just settle the case as a final settlement, but they have just discussed the particular facts actually took place and agreed on it. Should rules on approval of transactions be applied in such a case or not? Another question is, what about the claimant who waives the part of his claim in the arbitration proceeding? Such waiver of the claim, is it a transaction for purpose of approval under Russian insolvency law? From other side, if the debtor confess a claim in a part, is it a transaction under the Russian law? And this is a very big question because actually I think that all of us could find quite good reasons for any approach in this respect. We could argue that, of course, waiver and confession is a deal and a material fact for the purpose of the Russian insolvency law because it leads to alteration of obligation. From other side, you could say that no, actually, waiver or confession do not change the nature of obligation because the material substance of such obligation took place earlier and it already exists. And the fact that the party just recognized and admitted that it has a right or has not a right, it's not a change of the right itself, and it's not a deal. So I just want to point out that it might be a quite interesting field for battle if we're talking about necessity of approvals of the receivers or the creditors of the debtor in relation to such activities. So guys, do you have any idea in this respect? Should such types of settlement be approved by the receivers or creditors, or should not?
I think practically speaking, it matters when this settlement agreement is further used in the course of bankruptcy. And it could be if it happens, then it could be challenged by the creditors. Because my question was, is it not just mind games? I mean, practically speaking, how often such situation could occur? I mean, not pure settlement agreement, but agreement on facts or some confessions.
Let's imagine that we do have an affiliated creditor with a debtor, and they do have an ongoing arbitration proceedings, and they are actually controlled by the same people, by the same beneficiaries, which is, of course, is not quite clear for the third parties, and there is a kind of settlement between them. It's quite easy to struggle with it if they do have a pure settlement and they just agreed on something and it was approved by the arbitrator. But what if they have presented the case in such way that the tribunal just didn't have another way than just to admit the claim? But it wasn't a direct confession, but it was a type of such acting and by the defendant and the claimant in proceedings, which leads to a particular work. So actually, in Russian court practice, let's forget about arbitration. Yes, again, if we're talking about just a litigation and a separate proceedings prior to the arbitration, and it will be proved that it was an informal agreement between the claimant and the debtor, and it was an affiliated person, that is quite clear that you will just appeal such a Russian court judgment in a previous case, and then you will just get out this creditor from the registry. But what if we are talking about an arbitration, and what if we are talking about situation when such recognition or confession or waiver of the claim wasn't so clear for everyone? In such a case, it might be quite difficult to show that it's a shame transaction or a shame proceedings. In such a case, you should refer to the rules on approval of the transaction. but it's quite disputable from the Russian law prospects whether such particular steps in arbitration proceedings have to be approved as a transactions, or it's just procedural steps of representatives, which is not a deal by its nature. So it's quite an interesting question. Maybe somebody in the panel, I mean, our visitors, do have any idea in this respect? I see that Anton Alifanov is here. I see that. Just give me a second. Alexander Shevelev is here, and other guys.
Okay, I propose to speak about it after this session, because we unfortunately have only 10 minutes left.
10 minutes left, yeah.
Yeah, we have some other topics to discuss.
Do you want to go into your next slide?
Yeah. Thank you, guys.
Yeah, thank you very much. So the other situation which I want to cover is the bankruptcy of the plaintiff, and in my view, this situation is even more interesting. As I previously said, there was a quite interesting case of the Supreme Court, which was, I would say, expected by the community. I mean, legal conclusions of the Supreme Court in this case. So in this case, the Supreme Court ruled in favor of enforceability of arbitration clauses, but used some arguments when substantiating its decision, which could be further applied by claimants who are in bankruptcy in order to litigate, not to arbitrate, and to go to the Russian state court. So briefly speaking about this case, it was honestly not the case related to bankruptcy. So the claimant in this case was not in bankruptcy, but the main argument of the claimant, which skipped arbitration and didn't manage to pay 2,000 euro to initiate arbitration proceedings before Stockholm tribunal. The main argument was that claimant did not have enough money to pursue these arbitration proceedings, and that is why the claimant wants to initiate litigation proceedings before Russian court. So the court of first instance ruled in favor of the defendant and left the claim without consideration. This ruling was set aside by the appeal court, but then cassation appeal court upheld the first instance court, and Supreme Court finally supported position of the first instance court. But arbiter dictum, the Supreme Court said that in this specific case, it was not proved that the claimant did not have enough money to initiate and pursue the arbitration proceedings. But the Supreme Court said that there could be potentially some cases, for example, bankruptcy of the claimant, which could give an opportunity for the claimant to initiate litigation proceedings and skip the arbitration clause. Next slide, please. And after this case of the Supreme Court in 2017, to be honest, the case law in Russia remained the same, and the proportion of when the Russian courts they leave such claims without consideration, and they say that you should go under the arbitration clause is about 70%, and 30% they are against, and they say that if the claimant manages to prove that he doesn't have enough money, so it could go to the Russian state court. So here on this slide you see the main arguments which are usually used by claimants and defendants, vice versa, when they try to prove that the arbitration clause is enforceable and you should go under the arbitration clause, or when you are trying to substantiate that, you could go to the Russian state court. So
can I ask a question about that, Sergey?
Yeah.
So in this scenario, you have the claimant company is bankrupt.
Yes.
Presumably, it has trade creditors that are causing
yes.
the bankruptcy. Is it possible for the trade creditors to fund for it? So for example, in the common law, it is quite often that you'll have a petitioning creditor who appoints the liquidator via a winding up petition.
Mm-hmm.
And then there are actions that the petitioning creditor wants the liquidator to do. So there may be claims that the company has against third parties. And so the petitioning creditor will fund the liquidator in order to bring the claims in the name of the insolvent company. Mm-hmm. So in this case, this doesn't seem to take into account any form of funding from third parties.
So in Russia, the situation, in my experience, is quite different, because in many cases that is the argument of the respondent, who wants to have arbitration proceedings and who is ready to finance arbitration proceedings. So I've seen a lot of cases when the respondent, usually when the case goes into Russian state court, when the respondent says that you did not initiate arbitration proceedings, but if you did do it, I will finance your proceedings. And sometimes they even provide some evidence that they, for example, paid some money to the arbitration institution in order that the claimant could pursue the arbitration proceedings. So in most cases, in my experience, the creditors of the debtor, they are not interested in pursuing arbitration proceedings, just because in Russia, litigation proceedings, they're faster, they are simpler, they're cheaper. So it is in favor of the creditors of the debtor to pursue litigation proceedings in the Russian state court, not arbitration proceedings. Nikolay, you're muted.
I will say just about one exception from that rule when we are talking about the respondent, the debtor of the debtor. If such the debtor of the debtor is located outside of Russia, then in such a case it might be not so beneficial to get a Russian state court judgment in this respect, because it might be some tricky issues with recognition of such a judgment. And in such a case, it might be quite beneficial for the creditors of the debtor to get an award against the Russian debtor of the debtor. And in such a case, generally there are two types of financing. First of all, for the bankruptcy estate, and usually Russian receivers just, they appointing creditors meeting to get an approval of the creditors to spend money in such a crazy way. And the second option is just to get some financing from the creditors, so usually major creditors of the debtor who are interested to proceed with such arbitration proceedings. But unfortunately, there is no really good and clear procedure of financing of the receiver by such creditors within the scope of the insolvency proceedings. And sometimes it may lead to some payments in favor of the receiver, some debts between the creditors and receiver, which are not shown to anybody, and especially to the court. This is a way how the receiver collect money to start such proceeding. And then if they, just was quite successful in arbitration and get an actual recovery, then sometimes receivers just look back to such money to the creditor, but sometimes they could say, hey, I don't have any idea about what money is sent to me, just get your piece from the receivership estate and fuck off. So actually it's a quite tricky question that you raised at the moment, and unfortunately Russian law is not really adaptive to such kind of an issue.
Yes.
Okay. We've reached the limit of our talk. Should we see if there's any questions? And do you want to do your final section, Sergey?
Yeah, I can do it briefly. I think 1-2 minutes will be enough. So, coming back to the bankruptcy of the defendant or the respondent, I just want to share experience or one cases in which I took part last year. So that was the bankruptcy of the Russian company, and the claimant was the European company. So the amount of claims was very huge, like several hundreds of euro. And in this specific case, the proceedings were initiated before introduction of supervision of the Russian debtor company. And the main idea in this case was to obtain an award as soon as possible, just because the supervision in Russia usually lasts 7 months, so it could last longer, but in most cases 7 months or about. And in this specific case, our client, who was the claimant, asked about partial final award in respect of the main amount of claim, and this partial final award was provided to our clients, and the arbitral tribunal consisted of 3 QCs. They managed to provide an award 2 weeks after the hearings completed. Just like 1 week before introduction of the receivership procedures, so before declaring the debtor bankrupt. And I just wanted to say some words about the case law in Russia. So the case law is different, and here you see 2 cases with different conclusions. So in the TRK case, the Russian court said that you cannot recognize partial award, but a Silverburn case is in favor of partial final awards, which are provided by various rules of arbitration institutions, European arbitration institutions. And in this specific case, the court said that as in the final partial award, the case may be in part, but is finally resolved by the arbitral tribunal. So it means that partial final award could be recognized by Russian state court. And I used this, so I provided this slide to bear in mind that there is such remedy as partial final award, because in many situations where you have bankruptcy, you should be in a hurry, you should be quick and to obtain an award as soon as possible. And this instrument, which is provided by rules of arbitration institutions, is very good when you need to have final but partial award and use it further in the course of bankruptcy. In this case, of the bankruptcy of the Russian bankrupt company.
I will just add that it might be an interesting question of the nature of recognition of such award by the court, because there are mainly 2 options. Yeah, the first one is just recognition and make a binding effect of the award, like, you know, just a court judgment. And another approach and possible option is just to consider such an award as one of evidence of an obligation. So in such a case, it's not a formal recognition and binding effect of the award in insolvency. Still, it might be considered by the Russian state court as an evidence in relation to obligation, which might be quite useful as well, even if we fail, for example, to recognize it's like a binding award. So it's still be an option to use it in Russia.
Yes, yeah, then under common law, you might be able to get recognition of the award. But then essentially you'd have to put that in, and as part of the proof of debt, you'd use your award, and then you would stand. You don't get any security as a result of your award, so you'd be pari passu with other creditors in the bankruptcy estate. Right, we've got a few minutes. I think there is one question. Let's have a look. Can you discuss briefly the matter of public policy as a limitation to enforce an arbitral award that relates to insolvency?
This question just couldn't be discussed briefly because, unfortunately, there is a lot of Russian case law, quite usually embarrassing case law, saying us that from the prospect of Russian state courts, awards just nothing. It's not an evidence. It's not a binding act. It's just a piece of paper which should be considered as just a sign that the claim maybe it exists, maybe not. And then Russian courts usually just tend to reconsider cases on merits, while clearly should be allowed in such a case. And the most bulk of Russian Supreme Court practice, considering issue of a public policy in relation to the award, is connected with the question whether arbitration proceedings actually took place, whether parties actually filed the submissions to the arbitral tribunal, and whether arbitrators actually considered those evidence, and whether those evidence was provided. So the main tricky issue is to have a bundle of the evidence that yes, actually the arbitral proceedings took place, and the award is not an only evidence that they took place. Sometimes, due to this reason, for example, we are asking the arbitral tribunals to allow us for audio recording of the hearings, because usually it's an issue because of confidentiality of the proceeding, but if the party didn't object it, usually arbitral tribunal allows. This is making just in order to show the Russian state court in the future that yes, arbitration proceedings actually took place, the position of the party actually was presented, and etc., etc. So I will say that Russian domestic pocket arbitration has just diminished the value of the arbitral awards for the Russian state court in such a strong way that foreign arbitral awards by the respectful institutions also considers by the Russian state court on the same standards, and the public policy is the main, weapon against the awards in Russia.
But equally, I mean, if you have, suppose you do have, you've successfully had a long, hard-fought arbitration, you've achieved award, and then as the award is published, the defendant company against whom you've got the award is declared insolvent. How can that be enforced without prejudicing other creditors? I mean, there sometimes is a race to get your award recognised. But if the party has successfully filed for liquidation or has been wound up, how do you manage to enforce the award?
I think we are talking about the burden of proof, and the burden of proof to be presented by other creditors to show that this award is not consistent with the law. Or
But even if you get to the stage where you establish that the arbitration took place, it was all valid, etc. Under Russian law, how do you then enforce it? Because if there's a payment out, wouldn't that prejudice other creditors to the insolvent company?
We're talking about the enforcement in such a case, not as an enforcement separate to the insolvency proceedings. I believe that Sergey talked about enforcement in the insolvency proceedings. So when
oh no, I thought the question was about public policy, the limitation to enforce the arbitral award that relates to insolvency. I thought
if the question was considering situation when the award is enforcing our scope of the insolvency proceedings, then there is actually no chance to do it, and the basic argument against it is not a public policy, just a direct restriction by the Russian insolvency law. But if we're talking about the recognition within the scope of insolvency case, then the public policy argument just go to the front of the battlefield, and then we discuss this issue.
Anybody want to ask a live question? We've gone about 10 minutes over our time, but I'm sure we're happy to take any questions if anybody wants to put their hand up. Well, I think
just thank you.
It's more than enough.
Yes, it's more than enough. Yes. Well, thank you both for a very entertaining session, and hopefully see you both next year in Moscow.
Thank
you guys.
Thank you, Peter.
Peter, Sergey, have a nice day.
Thank you very much.
I think our session is the last one, so I hope everybody enjoyed the conference. So see you next year.
See you next year. Yes, hopefully live in Moscow.
See you live.
Thank you. Bye-bye.
Bye.
Bye.